Swayam Prabha. Digital India. Educated India.
Hello students, today we will try to understand the jurisprudence and Indian legal system. Jurisprudence is a term which is used by many people in different ways, and Indian legal system is our system. How these two things are influenced by each other, that is the task of today's students, that how they can understand that how Indian legal system and jurisprudence both are important and both need to be understood. In this lecture, we will try to understand the basics of jurisprudence, and then we will move on to see that how the first school of jurisprudence, that is analytical school, which is also called as positive school, that is important. We will try to understand this school. So, first of all, we will try to understand the meaning and origin of the term jurisprudence. Now, why do we want to understand the meaning of the term jurisprudence? Because this is the term which is used to understand the science of law. What is the meaning of law? So many authors, so many philosophers, they have tried to understand the meaning of law and the science of law. So, today also we will try to understand the meaning of jurisprudence. Has there been any tradition of jurisprudence in our country? That is also one of the things that may come to your mind. And the answer is that yes, we had also a long tradition of jurisprudence in our country, and that was called as Nyaya Shastra, Dharma Shastra, Vidhi Shastra in our country. So, you might have heard about different types of Shastras, and those can be Dharma Shastras, those can be Nyaya Shastras, and there were some people who called Vidhi Shastra. So, Dharma Shastra we will sometimes understand in a different lecture how the Dharma Shastras they influenced our legal system, and the jurisprudence, the modern jurisprudence which has been started in the 16th and 17th centuries onwards, how they have been influenced by our legal system, and how the Western legal system have been influenced by the Indian legal system. So, the modern legal system is very important to be understood because these times are the modern times, and we have to understand the modern times jurisprudence. Now, the backbone of the modern times jurisprudence, that is that had started from the Roman Empire. And during the time when Romans had used the term jurisprudence, that was very old, and they derived it from a Latin word which is called jurisprudentia. Jurisprudentia means knowledge of law. So, that was the context in which for the first time the word jurisprudence was used in the Latin term, but that is very old. But during the current times, during the modern times, Thomas Hobbes, who was a very famous author, philosopher of law, he had written a book in the 17th century, and the title of the book was De Cive. In that book, De Cive, he dealt with the nature of national law, government, and the concept of sovereignty. So, Hobbes' philosophy, Hobbes' law, and the book that he had written, although he had written many books, but in Decaive, he had tried to make us understand that what is the meaning of the word sovereignty, what is the meaning of the word government, etc. So, Thomas Hobbes, we can start with Thomas Hobbes. We can say that that book which started the journey in the modern times, how that journey that grew with time. Next famous author in this journey was Jeremy Bentham, and when Jeremy Bentham wrote a book, and the name of the book was An Introduction to the Principles of Morals and Legislation. That was in 1789. This was a book which became very famous, and that gave definite shape to the study of jurisprudence. So, Bentham's, you might have heard about Bentham's utilitarian approach, Bentham's many other ideas, but this Bentham's book, that became the basis of the further development of theories on jurisprudence in the modern times. So, this Hobbesian culture, this Benthamite views on jurisprudence, they showed the path to the future development of jurisprudence in the Western countries. And because in those times, in 18th centuries, there was colonialism, the Britishers, the French people, they were all having colonies in different parts of the world. Therefore, what we can understand that these views of those authors, those philosophers of the Western countries, they spread to all over the world. Next that we should try to understand is that the modern jurisprudence, that can be divided into different schools. Schools mean that whoever studies in a particular school, they all follow the ethos, they all follow the objective of that school. So, in that sense, the different schools of jurisprudence, it means that suppose if a philosopher is in a particular school and then if he has given a particular theory, then all the other people or philosophers or the legal theorists who will again do in the same line, they will be falling under the same school. So, this is the kind of school, and on that basis the jurisprudence, the study of jurisprudence can be understood by understanding at least 3 or 4 jurisprudential schools. So, the first school of jurisprudence is called analytical school, and we can also call it the positivist school. The second school of jurisprudence is called historical school. What is historical school? That also we will try to understand in other lectures, but today just I am telling you that there are 4 different schools of jurisprudence, and historical school is the second school. The third school is sociological school. Now, what is the meaning of this sociological school? Who are the proponents of this theory? These things we will understand in the different class, but today what I want to tell that this is the third school of jurisprudence. Thereafter, the fourth school of jurisprudence is called natural school of jurisprudence. Now, again in the same pattern that I have said, that natural school we will also try to understand, but what we should know that the basic schools of jurisprudence in the modern times are 4 in number. The first is analytical, the second is historical, the third is sociological, and the fourth is the natural school of jurisprudence. Thereafter, we will try to understand the first school of jurisprudence today, that is analytical school of jurisprudence. Now, analytical school of jurisprudence, as the name signifies, that it depends upon the analysis of different laws and rules and regulations. And therefore, the name has been given to this school, which is called analytical school. Analytical school is also sometimes called as positivist school. You will wonder, what is the meaning of this positivist school? Does it mean that positivist school means that someone who believes in positive way of life, or is it something else? Normal meaning of positive or positivism, that may be that yes, anyone who says that be positive in life, you have to think positive, that may be the normal understanding of this word. But in law, the word positive, the word positivism has a different meaning. Positive has been derived from the word position, and therefore, positivism means that we have to learn the position of law in the society. And positivism in simple sense means that what is the position of the written law in the rule book. So, it is not, positivism does not go to look at the laws which ought to be, the laws which may be drafted, but those laws which are there. There is no need to go to any other way of thinking, that the laws which might be there is no guess here. You do not say that law which ought to be there, which should have been there, but positivism, this theory that focuses upon the fact that what is the law, what law's position is today, where can you find the law which is given by a particular authority, which is a competent authority. So, these things are important, and therefore, we have to learn this positivist school today. Who was the proponent of this school? How he propounded this theory of positivism in those times, and how is it relevant today? These are some of the things that we will try to understand today. What I will tell you, that the proponent of analytical school was John Austin. Now, John Austin, who started giving his lectures, although you must know little bit about John Austin. John Austin had also participated in the World War, and he had studied his graduation, and thereafter what happened, that the World War started, and he went, because in those times conscription was there, everyone who was of a particular age, they had to participate in the war, if this kind of war, and that war was World War. So, he participated in that, and after coming from the World War, what he did, that he did not lose interest in studying of the law, and he started again the study of law in a different way, because he had looked at the structure of the military, how the military people they functioned during the war, what was the importance of command by the superior. These were some of the things that he had learned when he was there in the World War. And thereafter, when he came back, he started studying jurisprudence, and not only that, he had lot of interest in jurisprudence, and ultimately he held the chair of jurisprudence in University of London. In those times, University of London enjoyed huge reputation, and there he held a chair of jurisprudence, and that was for the first time that special, different, special kind of chair was created for him. That chair was called the chair of jurisprudence. Now, when he was in the University of London, he started delivering lectures to his students, and he loved his students. He every day regularly he went and delivered his lectures in University of London. And at that moment of time, students didn't realize that the professor who was teaching him, he would become so renowned all over the world. But at that moment of time, students just took notes of his lectures. But there were few students who not only took lectures, but they discussed the lectures with the professor. And there came a time when many of those lectures, they were stored and they were kept preserved in some place. And what happened that when John Austin died, during his time he could not publish his lectures in a compiled way, but when he died, his lectures were published, and there was a form of book which was given to those lectures. And the book, which he did not in his lifetime, he didn't see that what was the name which was given, but then what he wrote, what he lectured, that was published in the form of the book, and the title of the book was Province of Jurisprudence Determined. Now, he was telling his students that you see that we have to determine the province of jurisprudence, because the province of jurisprudence is vague and it has gone to many dimensions. The structure, the circle, the influence of different things are there on the jurisprudence, and therefore, we have to determine again that how and where is the limit of jurisprudence. We should not study everything under the garb of law. We should not say that law means nature. We should not say law means God. We should not say law means whatever rules we think of. But what he said, that what is the meaning of jurisprudence, that we have to understand. And therefore, it is very important that he started with his own theory, and that theory was called analytical theory, that theory was called positivist theory. And before going on to his main basics of the understanding of law, what we must try to understand is that how did he define law? And once we understand that how did he define law, then we can understand that in that very definition, there are so many strands of different things that we will try to understand. So, first of all, we will try to understand what is the meaning of law that John Austin said. Now, John Austin defined law as a rule laid down for the guidance of an intelligent being by an intelligent being having power over him. So, if you look at this definition, you will find that he first of all said that who makes the rule? So, he said that a rule which is laid down for the guidance of people. But who makes the rule? Again, by another set of people for the guidance. And then what he said, that who have the power over the other set of people. So, this power relation is also important, that what kind of power relation. It means that some people have greater power and some other people have less power, or maybe having no power at all. So, what kind of such relation, what can we call it? These are the things that he tried to further elaborate in his discussions. Now, if you look at the basic way in which he said that what is the meaning of law, although I told you that this was how it was defined, but then if you look at this picture, you will find that he had depicted law by saying dividing the law into different categories. Basically, he divided law into two parts. One can be called law properly so called, and the other was called law improperly so called. Now, proper, improper. One was called law properly so called. We can sometimes we are used to say so called, but then Austin had also used this term so called. Law properly so called and law improperly so called. Now, he said that law improperly so called can again be divided into two parts. One, laws by analogy, and the second, laws by metaphor. Now, these two types of laws are basically improper laws. So, he said that no, we should not study this law. These may be broader versions of law, but this is not the province of jurisprudence. And then in law properly so called, he again divided law properly so called into two parts. One, he said law of God, another he said human made laws. Now, as far as law of God was concerned, he said that it is law properly so called, but this is not the province of jurisprudence. He said that law of God can be like gravity, law of gravity, but this is not the law which is framed by human being. This is the natural law, the divine law, the God given law, but that is not the province of jurisprudence. We must understand that what is the province of jurisprudence, and there he said that the human made laws are the proper province of jurisprudence. And there he said again that the human made laws can be further divided into two broad categories. One can be called positive laws, and here comes the word from where the positivism or analytical method, those were derived. So, positivism. So, human made laws can be divided into two broad categories. One was called human laws and the other was called laws which are not set by men as political superior, and this is also called positive morality. So, positive morality means what? It is a kind of morality, and positive means what? That again the position of morality in that time in the society, that is very important. So, but then it is not law, it is not binding, it is what? It is just a positive morality, means morality which is existing in the society in some kind of form which may be in writing or in practice. So, that was called positive morality, and he said that positive morality, this is not set by the political superior, but it is just being observed, and therefore, it is called positive morality. So, you will have to eliminate all these other things, only then you can come to the human made laws, and that too which are positive laws. Human made laws can be laws by not by political superior, but it is called positive morality. So, what we have to understand that we have to focus upon the positive laws. Positive laws mean that those rules which are made by the political superior who are having control, who are having the power over the political inferior people. So, that is how the rule which are made, which are called positive law, here we have to focus, because that is the school of jurisprudence which is called positive school of jurisprudence. That is the school of jurisprudence that is called analytical school of jurisprudence. So, we have to go further and see that the definition that Austin gave, in that definition we have to first of all see that who are those people who have the power over the other set of people who are politically inferior, and therefore they observe the law. So, who are those people? And there he derived his understanding from the writings of Hobbes and Bentham, and what he said, that we have to understand the concept of sovereignty first. If we understand the concept of sovereignty, then we can further understand that how the sovereign uses the power to make the rules. So, concept of sovereignty is very important. Let us try to understand the concept of sovereignty, because what he said, that there is a great contrast between the positive law and the positive morality, and that great contrast is because of the fact that positive law is set by the political superior. And then he further elaborates that notion, and he further says that now I am going to develop this theory of sovereignty. So, what he says, that the political superiority, that is sovereignty. If a group of person or one person or a lot of people, if they enjoy the political superiority, that can be styled as sovereignty. And thereafter what he says, that sovereignty is indivisible. You can't say that sovereignty can be divided. It is not a metal, it is not an atom which can be divided. This is a sovereign, and sovereign is indivisible. Likewise, what he says, that sovereign enjoys power and there is no limitation upon his powers. No limitations. Without limitations, sovereign enjoys the powers. And therefore, what he says, that sovereign has lots of powers, and that is why the sovereign has also the power to make the rules, make the laws, and therefore, those laws are to be observed. We will also understand that what are the other things by which laws are observed, but before that we should also move on to say that he said that there are two marks of sovereignty. Identify. How will you identify? Sometimes it is very difficult to identify that whether there is a sovereignty or not, whether a person is a sovereign or not. Now, there he comes to rescue those persons, those students who say that sovereignty cannot be identified easily, but he said it can be identified. Let us try to understand some of the distinguishing marks of sovereignty. He said there are two distinguishing marks, and one is related to the other. So, once you understand the first, the second you should also understand, because both are linked. So, please try to understand the first mark of sovereignty. What he says, that the bulk of the given society are in the habit of obedience or submission to a determinate and common superior. Now, society has lot of people, and what he says, that not 100% of the society are in the habit of obedience, but he said bulk. He used the term bulk, not all, not 100%, but he said the bulk of the society. So, he did not say that every member of the society must obey, only then there will be a sovereign. He said that the bulk of the society, when they are in a habit of obedience, they are used to obey the command of or the rule which is given by the ruler. So, they are in the habit of obeying that, and who are obeying? The bulk of the society, and then the determinate and common superior. There has to be a determinate and common superior, because sovereignty cannot be vague, sovereignty cannot be there in so many number of people that you can't count. So, sovereignty has to be determinate, and that sovereign must be a superior. So, that is the first mark of sovereignty. The second mark of sovereignty, which is linked to the first, is that certain individual or body of individuals is not in a habit of obedience to a determinate human superior. It means that we have tried to understand that there are two types of people. One type of people are in the habit of obedience, they form the bulk of the society, and the other part of the society is composed of a determinate superior. So, that determinate superior, the second mark of sovereignty is that another determinate superior is not in the habit of obeying the command. So, the second is that superior, they are not in the habit of obedience to a determinate human superior. So, there is no one who is above them, and they are not in the habit of obeying any such anything. So, they are the rulers. So, you have to understand that, you see that how can we understand the legal notion of sovereignty and the distinguishing marks of sovereignty, and these are the two distinguishing marks of sovereignty by which we can easily now understand. And then the next thing is that Austin says that there has to be a sovereign in an independent political society. Now, independent political society is a sine qua non of making a sovereign rule over the people and making the rules which will be obeyed. So, what is this independent political society? So, what he says that a given society may form a society political and independent, and these two must unite. What must unite? The distinguishing marks of sovereignty, that also must unite. So, independent political society is important, and when you can see that the generality of the given society must be in a habit of obedience to a determinate and common superior, that was the first mark of sovereignty. And the second mark of sovereignty that we have seen, that the determinate person or body of persons must not be habitually obedient to a determinate person or body. Now, Austin says that this unity of these two, and thereafter only independent political society we have to imagine, meaning thereby that independent political society must not be subservient to any other political society. Independent political society means that the sovereign will not take any command or any guidance from other sovereign, and therefore, independent political society can take its decisions on its own. And how can it do such things? Unless and until the two distinguishing marks of sovereignty, they will not unite, and only then independent political society can be formed. Thereafter, we have to see that what is the simplification of the meaning of what he said, that law is a rule which is formed by the politically superior who is having control over the politically inferior. So, we have to understand in a simpler form that what can be the simple meaning of the word law. Now, law can be simply understood according to Austin by 3 letters. One is the letter C, other is the letter D, and the last is S. Now, C stands for command. What is the meaning of command? Command is the expression of a rule by the sovereign. That is called command. Command is, and where I have told you earlier that Austin served in the military, and therefore, Austin knew that what is the importance and gravity of the word command. So, he used the term command in law also when he gave his theory that positivism means what? Positivism means that the superior will give directions to the inferiors. So, in that way what he says that this is called command. Now, command is important. The first thing, the first component of law means the command, and who will issue the command? Political superior will issue the command. To whom the command will be issued? Politically inferior will be those persons who have to abide by that command. The second component is duty. Now, command will have no meaning if there is no duty upon the other persons. And who are those people who have the duty to abide by the command? That is the people who are not politically superior. Now, they have to abide by the commands of the politically superior. That is their duty. So, the first was that the politically superior will give command, and the second was that the politically inferior, they will have to abide by it, and that is called duty. The third component, he says that it is called sanction. Now, sanction means not only punishment, but also any kind of evil which can be inflicted upon the wrongdoer. What is said that sanction is important because command will be having no use if the duties are not observed by those people to whom the command were issued, and if duties were not observed, will that be left alone? Can it be said that okay, someone did not perform duties, even then there is no problem at all? This is not the answer. So, what Austin says that there must be some evil to be inflicted upon those people who did not observe the duties, who did not obey the command, and therefore, what he says that without sanction we cannot imagine any rule, any law, any sovereignty, any independent political society. So, what he says that law has 3 essential components. The first is command, the second is duty, and the third is sanction. Now, sanction, duty, command, without these there is no life of any law, and without independent political society, without the sovereign there at the top, there is no existence of the positive law. And when all these things are fulfilled, when all these things are completed, then the sovereign issues the command, and there is a whole system, that political system is there by which the duties are observed by those politically inferior people, and thereafter there is institutional support. The political and institutional support is given to those people who have to enforce the sanctions, and then the whole law, the vision of law that Yes, law means binding rules, those rules which are binding upon the people. So, only then we can imagine that laws are those rules which are binding upon those people who are politically inferior, and rules are issued by the politically superior people. And if there is no observance of duties, then punishment will also be inflicted. Now, if you have understood the basics of Austinian theory, we have to understand that can this theory be said that okay, it was very good, or can we also analyze and then say that no, this had some certain shortcomings. So, we will look at this, because now we have tried to understand the basic contours of the positive school. So, we have to now understand that how can we understand the shortcomings in the Austinian approach. Now, if you look back, you will see that Austin did not consider the practices of the people, what the people observed, the custom, what people followed. So, he did not try to understand the importance of those people. Maybe that he was born in Britain, and maybe because of the fact that Britain had control all over most of the parts of the world, and therefore, if he would have said that the custom would be also given importance, maybe that the law making might have been very difficult. So, but whatever be the reasons, one thing is very certain, that when Austin said that no, who can make laws? The sovereign can make laws. Who can make laws? The political superior can make laws. But then in those times, Britishers, they had colonies all over the world. So, the laws, who would make the laws? Those laws would be made by the Britishers sitting in London, and John Austin was also there in University of London. So, did he say that the whole power was vested in some of the people in London, or the people who are there in the colonies? So, he did not, he just overlooked all these things, and he said that no, legislation is very important, law making is very important, and who makes the law? It is not that the local people should be given the power to make the laws, but it is who enjoys political superiority. So, he did not give any importance to the custom. Secondly, he did not also give relevance to the judiciary, the judges. He did not say that judges can also make laws, although judges are also the wing of the state, but he also overlooked the judge made law. Today we can understand that, you see that how judges, they are making laws, but in those times also, in England also, there was a tradition of making laws by the judges. But the theory of Austin that overlooked the judge made law, because he was saying that the political superior, now judges are not, they are just wing of the state, but they are not politically superior. So, what will happen to that? So, this thing also is missing in Austinian theory. Another thing that we should understand as a student of law is that can an individual make a binding agreement with other individual? And if that is so, whether that will fit into the whole category of Austinian positive school? The answer is again yes, because one individual can agree with other individual. So, if that is acceptable, where can you place the politically superior people? Who is politically superior in this case? When two individuals are agreeing, there is no one who is the political superior, they are both at the same platform, and that is called the law of contracts. And Austin again overlooked this aspect, that whether law of contract, that can also be called law. So, in his theory, maybe that law of contracts will not be considered as law. International law also. When he said international law, he placed international law in the category of positive morality. Maybe that because of his times, that was the time of 18th, 19th century. In those times, whatever rules which were framed by some 4 or 5 countries, those were to be, maybe that they could be called as positive morality, and that was not one empire that could make one laws, other empire could make other laws. So, that could not be called. So, that was one of the reason, but can we say that international law is not law today? Can we say that international law is still a positive morality in today's times? The answer is no. So, Austin can also be criticized for the fact that he said it's just international law is just a positive morality, but that is not the fact today. In today's times, Austinian concept of having only international law, just a positive morality, will not fit. So, international law is also a law today. Next is that morality and law. Did he say that law has any kind of influence from morality? He said that okay, there might have been some influence from morality, but then we have to determine the province of jurisprudence by saying that we will exclude morality from the law. So, there was no place in the whole scheme of Austin about morality. So, he says that morality, but can we understand this in today's times? Even today we can see that sometimes morality is influencing the law making. Maybe that you can say that legislators, they may consider morality at one point of time or the other point of time, but take for example, the example of homosexuality. There was a time when there was no such law on it, but today there is a law on it also. So, we see that morality cannot be just excluded from the domain of law, the domain of jurisprudence, and therefore, Austin somewhere overlooked this place of morality in his theory. The next is that when he said that law is only those rules which are issued by the politically superior, it meant that some of the other things, those were excluded. Like you might have heard that a person can make will. What does that mean? That if I want that my property, whatever property I have earned, whatever property I have accumulated, that can be given to someone else, and that someone else may be decided by me, because I have accumulated the property, because I have earned the property. Now, this is the power of making will. If that can be done, this is the power of making a will. So, the power of making will, if it is there and if the courts recognize it, then can it be called law? If will is not recognized, then we can say that no, this is not law. But the fact is that will is recognized by law if it is properly, if it fulfills the basic conditions which are given in the procedural laws. If that is fulfilled, then will is also recognized. So, who makes the will? It is the individual, it is not the political superior, but who can have the power to make will? The power to make the will is there in the individual, and that individual is not political superior. So, here also the theory of Austin, that will also fail. So, we have to, whenever we try to understand Austin and his concept, we also have to understand that can we say that Austin's theory is applicable now? because in today's Bharat, we have also to understand that Austinian theory, the relevance of that theory. Now, we can say that in ancient India, there was no such concept of sovereignty in the sense which is understood by Austin. Sovereignty under ancient Hindu law laid finally with God, and God delegated the power to rule to the king and to the people. So, sovereignty, the concept of sovereignty which was given by Austin, that was different. He said that no, there has to be political superior. So, it meant that you can understand that, you see, this whole empire system, the colonial system by which the Britishers, the French, the Portuguese, the Spanish people, they spread their colonies all over the world. Because of that fact, this kind of theory was developed, but in our country there was a different kind of concept of sovereignty, and that was legitimized by the God himself or herself. And in our country, Bharat, what we say, that final sovereignty and ultimate sanction, those lied with the God. Even the kings or queens, they could not punish beyond what was written in the practice or in the Shastras or in the Vedas. So, that was very important. The king could neither make or unmake the laws. In those times, it was not in the domain of the king to make laws. So, you see the contrast, that the Austinian concept of sovereignty was that sovereign can make all rules, all laws. But you see the contrast, that in our country, what was there, that okay, king is there, king has the duty to rule, but king was not having the power to make any kind of laws. Laws are to be discussed, laws were to be made by the lawgivers who thought, who debated, who discussed, and those became the sages. So, that was how you see that in our ancient times, this kind of concept that prevailed. In independent Bharat, sovereignty has become also limited. We have the parliament, and the parliament has the power to amend the constitution. So, the ruler, the political superior, can make a law, and thereafter they can also amend the constitution, but can it not be challenged in the judiciary? The answer is yes. And the laws which are made by the parliament, laws which are made by the political superior, that can be challenged in the courts. And therefore, we can't say that there is a limitation, there is no limitation. There is a limitation in our country, and that limitation was imposed by the judiciary, and Austin did not recognize the judge made laws, but in our country the judiciary had recognized this in Keshwaran Bharti versus State of Kerala way back in 1973. So, it means that the concept of sovereignty as propounded by Austin, that will not be of that much relevance, it will not be fully true in the current times, and the tradition in our country has been also that the God will have the final power with him, not the king. And thereafter, what we can see today, that sovereign is also divisible. There is a separation of powers concept, and sometimes judiciary can make laws, sometimes executive can also make laws. So, here it can't be said that the political superior is totally indivisible. Sovereignty is divisible, and better would be that sovereignty can be divisible. Once we have understood all the basic things about the analytical school, positivist school, you must try to look at these questions, and these questions are just basic questions Why was Austin's theory of law popular? Just see that why, because he was born in 18th century and this is 21st century. For the last 200 years his theories are being taught. So, why did he become popular? And what do you mean by the term independent political society? Because to understand Austin, we have to understand independent political society. So, this is also the question which may be relevant for you. You can also try to give some examples of positive law, and I have already told you that the examples of positive law can be the laws which are passed by the legislature, who are the politically superior people. If they make laws, those are the examples of positive laws. And then lastly, that what is the importance of Austin's theory? You have seen that Austin's theory might have been very important, that laid down the foundation of the other schools of thought, but today it has not that much of relevance. So, with this we thank you for your time today. I hope that you enjoyed today's lecture and you understood the basics of jurisprudence, the meaning of jurisprudence, and the first school of jurisprudence, that was analytical school. Thank you so much.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem, but as a sociologist you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation, at what age did your grandmother get married? You may find that she got married even younger, 18 or possibly even younger than that. So, this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by a biography we can also think of the biography of a particular problem with history. What has happened in the past? How is that connected to this individual or this problem in the present? Thank you.